This is a discussion of a very difficult, sensitive, complicated issue, torture, and specifically focused on the question of whether the victims of torture have a right to care. The Wilson Center is proud to co-sponsor this event with the Center for Victims of Torture. It's important that this discussion be able to take place here, I think, and I think the Wilson Center is a particularly good place for us to get into the difficult issues that our truly distinguished panel will present from various perspectives. Douglas Johnson, the Executive Director of the Center for Victims of Torture, the CVT, will introduce our panel in a moment. But first I'd like to say a few words about the center and about Doug himself. The mission of the CVT is to heal the wounds of torture on individuals, their families, and their communities, and to stop torture worldwide. It's a private, nonprofit, nonpartisan organization headquartered in Minneapolis with offices in St. Paul and Washington, and healing centers in Jordan, Sierra Leone, and the Democratic Republic of Congo. Since 1985, it has helped 20,000 torture survivors rebuild their lives. Doug Johnson has been the CVT's executive director since 1988 and a committed advocate of human rights since the 1970s. He helped lead a worldwide boycott of the Nestle Corporation to force it to change its marketing practices for infant formula, and he's been a consultant to UNICEF, to WHO, and to several Latin American human rights organizations. He's been an associate fellow of IPS here in Washington, and in 1982 was recipient of Letelier Moffitt Human Rights Award, in addition to other significant honors. He holds a master's degree in management from Yale University. Before turning the meeting over to him, I'd like to take, as a point of personal privilege, a moment just to say a few words about one of our speakers today, Elizabeth Lira. One of the blessings for those who are part of the movement for human rights is working with extraordinary people who make up this truly international community. Elizabeth is among the most memorable that I have known. There are very few who have given so much to the cause of human rights in such varied ways and over 4 decades as she has. Or, I might say, who are as qualified as she to speak from experience about survivors of torture. She's been involved personally and professionally in all 3 dimensions of human rights in the regime transitions of our time: truth, justice, and reparation, something that I'm sure Doug will describe in more detail. What I'd like to highlight here and now is Elizabeth's particular authority to address reparation for victims of torture. It's an intellectual authority based on research and reflection. It's also a practical authority drawn from her role in designing effective public policies. But it is ultimately, I think, a kind of moral authority that comes from working directly with torture victims and their families over many years in her native Chile and other societies in Latin America and elsewhere in the world. It's a particular pleasure to have Elizabeth with us today. Douglas Johnson.
Thanks, Alex. Welcome, everyone, to this forum. Is there a right to care for victims of torture? I just briefly introduce the panel and the framework for the discussion. With us today, as Alex pointed out, is Dr. Elizabeth Lira from Chile. Elizabeth is here because she is the winner of the CVT's Eclipse Award, which will be presented tonight at the museum from 6 to 8. If you don't have your reservation in, come anyway and celebrate this extraordinary person with us. And let me tell you about why. I first met Elizabeth in 1985 when I was dragged along by a couple of friends from my home in Buenos Aires to Santiago to visit with people who were working with victims of torture, by a couple of friends who had hoped to start a treatment center in Los Angeles. And I just say at that point they were both a little bit peeved because they had hoped to start the first treatment center in the country, and they were angry that Governor Perpich had beat them to the punch in Minnesota, and there already was a center started. But it was not in my fantasy to work with victims of torture at that point. And I would have to say, despite that, Elizabeth Lira made an incredible impression on me. Her intellect, her seriousness, but also the sample of commitment that she had. And what I remember from that point was the description of being a young therapist, pretending to be the sister of political prisoners, and getting into prisons in Chile under that pretense and providing therapy in the middle of the prison as they walked up and down the aisles. So just even to imagine, based on what we thought about Chile and how little political space there was, that there was an opportunity for family members to visit in prisons and an opportunity for a therapist to sneak through under that and provide care was gutsy, but it also, I think, demonstrates that that one of the important features of the treatment centers around the world is under the framework of healing, is the opportunity to slip in, even in highly repressive regimes, and create and expand political space, create space where people can begin to gather and lose their fear. And the issue of fear, of course, is paramount. It's the purpose of torture is to shape cultures through fear. And it's our role in care programs is to figure out how do we help communities address fear so they can become self-activating, politically engaged, and in control of their lives in the future. What we're talking about today is a section of Article 14 of the Convention Against Torture and the Right to Care. And over the last 20 years, there's been an important political dialogue in Chile as the democratic governments had to face what to do with victims of torture. What did the state owe to them? And Elizabeth has had an important role both in raising that question, but also participating on 3 national commissions and roundtables that had specific mandates under parliamentary law to address the question. And she's going to describe to us what that process looked like, what were the struggles, but also in recognition that Chile has moved forward in this field more than anyone, but Latin America and the whole has addressed the problem in various forms. Again, I would say more than any other place in the world. So we're looking forward to her commentary on that. Also with us is Juan Mendez, a human rights lawyer of great renown and repute, particularly dear to me because when my wife was a poor WOLA intern in her youth, supposed to work on Argentina, Juan was her mentor, and we've been in love with him ever since as he's continued to make incredible contributions to the human rights field. Officially, he's here today in his capacity as the UN Special Rapporteur on Torture. And we're looking for him as a lawyer and as a special rapporteur, to give his views on the meaning of the phrase in Article 14 as full a rehabilitation as possible. And on his left, Lorne Krainer, who's the president of the International Republican Institute. Lorne has been involved in democracy building for a long time, but in his stint as Assistant Secretary for Human Rights, I think he came to the view that the traditional fight between is it human rights or democracy was really the wrong fight, and that he came to be a proponent that democracies had to be built on a human rights framework. I also want to point out that we at CVT undertook a rather major symposium on tactical innovations in human rights, a symposium that took place in 2004, a new idea, a risky concept, that only succeeded with the backing of Lorne Krainer and his challenge to the rest of the State Department to participate. So I also hold Lorne quite dear, and we have asked him to be here to comment from a policy point of view about the difficulties and the practical operational issues that might be affected in this. Again, now, just to set the framework, relying on my trusty BlackBerry, let me read Article 14 of the Convention Against Torture. Each state party shall ensure in its legal system that the victim of an act of torture obtains redress and has an enforceable right to fair and adequate compensation, including the means for as full a rehabilitation as possible. In the event of the death of the victim as a result of an act of torture, his dependents shall be entitled to compensation. So that's the phrase we're looking at. What's the meaning of that? Does that mean that there's an entitlement? And if there is, if it's not an entitlement, what other means do governments have in order to become in compliance with this, with Article 14? If it is an entitlement, what's the shape of that? Is as full a rehabilitation defined by the state of what we knew about rehabilitation in 1985 when this became a treaty? Or has the new research on the effects of post-traumatic stress disorder and new combinations of care programs that seem to be more effective, are those part of the entitlement? What happens in a situation in a country where there's no mental health capacity, where there's a strong competition for resources on many needs in society? How do torture victims stand in the political decisions on achieving that entitlement or the right to care? Those are the broad questions we would like to address. And peeking behind everything, as we look at the experience in Chile, let's think about the political discussions and conflict there in the context of the question that we have as Americans for victims of torture from our own government. Do we have an obligation to them, whether they're guilty or not of terrorism? Or do we have an obligation to the 400,000, 500,000, 600,000 victims of torture who live in the United States, but who fled here from safety as refugees and political asylees over the last 40 years? So we begin this by calling upon our colleague, Dr. Elizabeth Lira.
Well, I apologize for my English, but I will try to do the best. I think that the sense of responsibility toward the victims of torture is ancient. If you read Hebrews 13:3 say, remember those who are in prison as though you were in prison with them, those who are being tortured as though you yourselves were being tortured. I think that these words express some of the elements that was part of our work from the beginning. Today, our discussion focuses on the use of torture by the powerful, whose discourse undermines the victim's suffering in order to legitimize policy sustained by terror. Our concern is with the moral and political struggle to push the state to accept its responsibility, as stated in the Article 14 that you have read before of the Convention Against Torture. I will use the case of Chile to exemplify that struggle which, while distinctly shaped by the characteristic of our own history, has encountered the same resistance and sought the same objectives as struggles in other parts of the world. In Chile, during 13 years, recognitions of and reparation for torture victims were postponed. I was thinking that in the beginning, in 1990, when we recovered the democracy, torture was considered a very great problem to face at this moment. In Chile, within a few months after the military coup on September 73, we witnessed the devastating impact of terror, torture, and extrajudicial executions, murder, on thousands of people. The violence the regime met out mainly against social, political, and union leaders was not in vain, effectively dismantling the opposition of the military junta, and in a culturally authoritarian country, the exercise of repressive power was devastating. Human rights violations committed under the military regime for 17 years severely affected the mental and physical health of the victims, including thousands who were tortured and indirectly family members, friends, and colleagues. Human rights institutions, Cooperation for Peace Committee, and the Social Aid Foundation of Christian Churches, at the beginning, they started on 1973, 1975, were created with the support of various churches. They offer initially social support and legal defense to a certain number of former political prisoners, to the families of disappeared detainees, and persons executed for political reasons, the relatives, and all persons persecuted and their families during this period. The consequences of political repression unleashed in that period were identified as traumatic experience for individuals and their families. Professionals developed a model for clinical medical care and psychosocial care using various forms of intervention: medical, psychiatrist, family and group therapy, and social support, according to the needs of each individual and his or her family. From the beginning, this approach recognized the fundamental need for society to acknowledge the victim's suffering and the therapeutic value of both access to justice and symbolic and solidarity actions on their behalf. All these measures were understood to encompass part of an integral rehabilitation process that included the restoration of the victim's rights. During the dictatorship, of course, the regime did not acknowledge that torture was a systematic element of government policy, just as it denied the policy of disappearance, that is, kidnappings and extrajudicial execution. Most of the professionals who undertook that task were unaware of what our work would entail and its implications, and I was no exception in that respect. By the end of the dictatorship, 6 mental health teams operate in the various human rights organizations of Santiago and another 4 in the province, most under the auspices of various churches. These mental health themes share the firm conviction that therapeutic work must be conducted with the best professional resource available, as rehabilitation depends on prompt implementation of integrated forms of care, medical, psychiatric, psychosocial, and medical specialties as needed. I started working at 77 in the mental health staff at FASIC and the Social Aid Foundation of Christian Churches. And then in 88, we worked in several provinces and created the Latin American Institute of Human Rights and Mental Health. I met Douglas Johnson in Chile, as he said, and we forged a collaborative working relationship that has endured to this day. I was in Istanbul and other cities of Turkey with a team of CBT in the middle of the 90s, endeavoring to build effective cooperation with professionals who work with torture victims of that country. As professionals, we worked with victims during the dictatorship. We did not regard our work as a humanitarian vocation, but rather as a response to the victims' need to recover autonomy and independence, to enable them to work, participate politically if they so choose, to generate the best living conditions for themselves and their families by freeing themselves from paralyzing fear by working through their traumatic experience. We had to find technical resources adequate and sufficient to meet the needs of children, youth, women, and men working through what had happened to them, and finally the resources to allow them and us to situate them again in the flow of life. I think that it was useful, but we haven't time, to identify our work during the dictatorship. But I think that the most important thing is try to answer the question of that is the title of this meeting. And I think that the question we ask today is what rights do torture victims have to reparation, and can those rights be vindicated? I mean legal and political rights, and putting the question that way means that I focus on public policy and government action that provides reparation to torture victims. In the Chilean case, such reparation policy has developed gradually since 1990, beginning with the acknowledgement that torture actually took place, then with limited health service, and finally with small monetary lifetime annuities for survivors and their immediate family members. Yes, the survivors have the right to care, but the guarantee for implementation of this right and the conditions for full rehabilitation depended on decisions of the elected government between 1990 to 2010. In our case, some reparation was possible for victims because of the experience and collaborations of the solidarity networks of health and mental health professionals created during the dictatorship with political allies in the Congress, the executive branch, journalists, human rights lawyers, and a changing political environment over the last 2 decades. I turn now to the reparation policies gradually adopted after 1990 in Chile. In April 1990, President Patricio Aylwin created the National Commission for Truth and Reconciliation. This was known as Rettig Commission for his president, Raúl Rettig. The information compiled by the Truth Commission and the Corporación for Reparation and Reconciliation after 4 years after the Commission recognized that we had 3,186 victims recognized by the states as relatives of disappeared people, as executed people, disappeared people, and victims of the political violence. The Commission proposed reparation measures and offered specific consideration regarding the health service for victims of human rights abuses. And in the report was written that health officials must develop a special program with funding and coordination from the Ministry of Health. This program would seek technical cooperation from non-governmental health organizations, particularly those that have provided health care to this population and have amassed valuable experience over all these years. During 1991, the National Congress enacted the General Reparation Law, and we had only the law for this health program in 2004. During all these years, it was possible to work only with the support of the Health Ministry. The Rettig Commission report became the foundation for future progress in criminal investigation, but at the time of its release, the Armed Force, Carabineros, National Police, and the Supreme Court all vigorously reject its finding. In any case, investigation of torture and torture victims was outside the mandate of the Rettig, notwithstanding the fact that evidence exists that almost all the victims identified by the Commission had been tortured and that almost 40% of them died as a result of torture. Reparation for victims of torture was not mentioned in Concertación. It was the coalition that governed Chile in between 1990 to 2010. Political platform appear the tortured victims, and it was postponed to address the reparation of tortured victims. We had the recognition of other kind of victims and several policies for the people who were in exile, the people who were politically dismissed, but the tortured victims appear only at the beginning of the government of Ricardo Lagos that started in 2000. During the time that Pinochet was arrested in London, it was created in Chile in between 1999 and 2000, a roundtable dialogue of human rights, Mesa de Diálogo, convened by the government of the time with representative of armed force, representative of churches and other groups, for example, Chilean Masonry, human rights lawyers and academics to deal with pending human rights issues, particularly the situation of the disappeared, looking for information about their whereabouts and final destination. The dialogue roundtable was installed when Pinochet was arrested in London. The government invited me to participate in the dialogue roundtable for my academic work and my experience of more than 20 years of clinical work with victims. As a result of agreements reached in the dialogue roundtable after 10 months, the armed forces acknowledged that about 150 missing detainees had been thrown into the sea, repudiating such acts as reprehensible. Almost 1,000 cases of disappeared persons remain without any information. This declaration in 2001 marked an important, if limited, turn in the armed force cooperation in relation to judicial proceedings on human rights cases. Well, the problem of torture was really important in the case of Pinochet London arrest. The House of Lords rejected a finding of immunity, but limited the proceedings regarding the crime of torture. 2 cases occurred after September 29, 1988, the date when torture became an extraditable crime in Great Britain. Judge Garzón supplemented his extradition request with 53 cases of torture committed in Chile between October 1988 and March 1990, along with 1,198 cases of disappearance. Pinochet has also a growing backlog of querellas, criminal complaints, and other victimizers that made visible the widespread use of torture during the dictatorship and illustrated the range of people and groups in different parts of the country who had suffered torture since 1973. They also highlight the fact that political prisoners and torture victims had not received official recognition of their suffering or reparation of their injuries in the first 13 years of elected civilian governments. Likewise, the criminal justice system had not applied Chilean or international law to prosecute the criminals. The President, Ricardo Lagos, the 12th of August in 2003, told the country that it was not possible to simply turn the page on past human rights violations and to deny the past and remind Chileans that state agents had persecuted, tortured, murdered, and forcibly disappeared persons throughout the country. He insisted that the victims' family and all Chileans had the right to know the truth regarding these atrocities, backed by a growing political consensus regarding the government's obligation to address past human rights violations. Lagos announced the creation of the National Commission on Political Imprisonment and Torture. I was member of this commission, and we received more than 36,000 people who ask for reparation. We recognize about 28,459 persons. The other people are out of the mandate. Everyone who testified before the Valech Commission described extremely violent arrest. Some victims were taken by state agents in front of their children in the middle of the night amid shouts, blows, and death threats to the victims and family members, creating an atmosphere of terror and anguish. This was part of the words that we put in the report. The report confirmed that torture consisted in abusive treatment, and we describe all the kinds of torture methods using during this time. The Commission identified also 1,132 detention centers throughout Chile where people were held and tortured. It established that on the day of the military coup, September 11, 1973, people were tortured in military bases, police precincts, naval ships, stadiums, prison camps, jails, and secret prison operated by the intelligence service. The Valech Commission established torture was a systematic practice during the military regime and was a policy of the government. The report confirmed the victims' legal defenseless, considering the judicial branch denial of the habeas corpus writs filed from 1973 to 1988. The civil courts renounced their jurisdiction authority bowing to the military courts. Victims who were charged and convicted by war tribunals, Consejo de Guerra, lacked even the most minimal due process guarantees. The report determined the political imprisonment and torture constitute a state policy of the military regime which promote repression, allocated public funds to it, and assigned personnel to carry out such repressive actions. The Valech Commission assigned varying degrees of responsibility to the armed forces, secret police, carabineros, and the judiciary for the crimes and human rights violations identified in its reports. For the first time, this institution, with variations, acknowledged the responsibility, not only for the crimes of the past, but for preventing such crimes in the future. Illustratively, Army Commander General Juan Emilio Cheire declared publicly that the Army had taken the difficult but irreversible decision to assume responsibility as an institution for the criminal and morally unacceptable actions of the past. He added that the Army shared the pain of the victims suffering from these violations of human rights and recognized that they were treated in a way inconsistent with the permanent and historical doctrine of the Army. The identification of victims entitled is not finished for reparations. On February 13, 2010, it was created a new commission, the Advisory Commission for the Qualification of Disappeared Detainees, persons killed by extrajudicial execution, as well political prisoners and victims of torture in the same period of the dictatorship, in accordance with some transitional articles of Law 20,405 that created the Institute of Human Rights. The Commission received more than 30,000 requests. At the end of its mandate, the 17th of August, next August, on 2011, it will deliver to the President of the Republic the list of certified victims who may request all the benefits to which they are entitled according to the reparations laws. Well, my final reflections on that is human rights violation comprises the core issue that united political opponents against the military regime. Thousands of people were galvanized by the cause, creating public pressure that began to change the situation. At the same time, it was fundamental that opponents give serious thought to how we could contribute to the formulation of human rights policy after the dictatorship. It was vital that we identify the complexities and challenges associated with human rights policy, anticipate the task that needed to be undertaken, and foster reflection to engender the understanding that reparations for victims must go beyond mere administrative or symbolic measures any government might implement. This task originates with solidarity work of human rights organizations and continue to unfold in the course of implementation of human rights policies during the political transition. We have learned that Truth and Truth Commission represents a point of departure, but the victim's personal truth and the rights to moral and legal reparation is built partly through criminal prosecution and partly through the political battle to enact legislation establishing the rights to particular forms of reparation for the human rights abuses committed by state actors. Victims obtain moral, social, and political reparation when the specific truth concerning what happened to them is publicly acknowledged, affirmed, and perpetrators are sanctioned. Truth also presupposes recognition of the damage that victims and their families have suffered, as well as the right to rehabilitation and compensation by the states. Well, we have more than 1,446 investigations in the as judicial process. Only 231 individuals have been found guilty in confirmed final sentence. Only around 30% of those convicted, 68 persons, for these crimes have received sentence involving actual jail time. Only 3 cases are condemned for torture issues. We have at this moment 25 judges designated exclusively to investigate these cases of human rights violations committed during the military regime. Finally, I can be said that the scope of reparation has broadened thanks to process of history, memory policy designated with the participation of victims' associations. Human rights issues and memory process have been developed in the arenas of education, culture, and among academics dedicated to research and on social memory. Yet, just as the military government justified repression while denied that torture and disappearance occur, in the name of common good, the eradication of or torture as public policy can be ensured only in the framework of ethical and political convictions and values that take roots in a society which permeate and are expressed in political, institutional, family, and every sphere of human relations. The eradication of torture requires an ethical and political conscience centered on human dignity and recognition of individual rights, even in time of crisis. But this is a task in perpetual construction, not only in Chile, but also by a major part of the global community, included here in the United States and democracies of Europe. Thanks.
Thank you, Elizabeth. Now we turn to Juan Mendez.
Thank you, Douglas. I'm really honored to be invited to speak by the Center for the Victims of Torture and in a setting such as the Wilson Center. But it's also a great privilege for me to share this podium with Elizabeth Lira and with Mr. Kreiner. The prohibition of torture in international law is a jus cogens norm, and that means that it is a norm of a special hierarchy and category in international law. It's only a handful of norms that can be said to be jus cogens, and jus cogens simply means that it's a norm, it's a peremptory norm in international law that cannot be superseded by a treaty norm or by an emerging custom that goes contrary to that norm. It's also not dependent on whether a state signs and ratifies a treaty. It's a norm in international relations that is crystallized as having that special category of a peremptory norm. And that's why torture in international law is unique. Even among violations of human rights, torture has a unique place in international law because the prohibition is absolute. It does not allow for any excuse based on an emergency or an exceptional situation, and certainly it does not allow for a suspension on the pretext of redefining what constitutes torture and what does not constitute torture. In addition, torture is an international crime, but here, again, it's unique as an international crime because unlike, say, extrajudicial executions or disappearances, a single act of torture evokes and involves the obligation of the state to investigate, prosecute, and punish the event. It doesn't have to be part of a pattern of gross and consistent violations. Of course, if it is, it's an aggravated form, but a single act, engages that obligation of the state. And the state then is obligated, has a duty to investigate and prosecute every single act, but also has a duty to offer reparations to the victims. That has now been included in the Article 14 of the Convention Against Torture that Douglas has read only a few minutes ago. So, and essentially torture is then a breach of an international law obligation. And we know from 1927, in the so-called Chorso factory case of the Permanent Court of International Justice, which is the predecessor body to the current International Court of Justice, that it is a principle of international law that the breach of an engagement involves an obligation to make reparation in an adequate form. And this last clause, in an adequate form, means, in my mind, that it depends on the form of the reparation depends on the pain and suffering experienced by the victim. And that's why, very wisely, Article 14, in the case of torture, because it is recognized that torture cannot be simply repaired or compensated by a lump sum, that Article 14 of the Convention Against Torture requires this norm of rehabilitation, which is not that easy to define. But it is a recognition that reparations have to be integral ad integrum, in the sense that compensation per se may not be an adequate form of reparation. Fortunately, now we have many different organs of protection of human rights, and both at the international and the universal level, but also in regional bodies like the Inter-American Court of Human Rights and the European Court of Human Rights, the African Commission on Human Rights, that over time have interpreted these norms and have from time to time given content to the right to reparations. There are many cases to cite, and I'm not going to do that, but suffice to say that the Committee Against Torture, as the committee that is the authoritative organ of interpretation of the Convention Against Torture, has repeatedly found states in breach of their obligation, even when some compensation was paid. Those breaches can be, for example, by not having legislation that enables a complainant to obtain redress and to be provided with fair and adequate compensation. In cases against Serbia and Montenegro, for example, the committee found that the absence, the legislation was such that the absence of a criminal investigation also deprived the victim of the ability to obtain civil damages because of the requirement of having first a criminal conviction before being able to pursue civil damages. And that, in fact, was found to be a violation of Article 14. These bodies have had recourse to a very fundamental body of principles that maybe are considered soft law in international law, but carrying a lot of weight. And those are the basic principles and guidelines on the right to a remedy and reparation for victims of gross violations of international human rights law and serious violation of international humanitarian law. This is a body of principles adopted by the General Assembly in 2005, but originally written and drafted by one of the predecessors in my mandate as Special Rapporteur on Torture, the Dutch jurist Theo van Boven. And even at the time when Van Boven was drafting these principles in the early 90s, he was very mindful of what the victims wanted and what the victims needed. And so the right to compensation was meant at that time to include the right to see justice done and the right to have the truth explored and disseminated. So it couldn't, a state could not escape its obligations by simply offering money to a victim of torture or of other serious human rights violations. The Committee Against Torture even found Spain in breach of this violation in a case where it had actually paid compensation. But it had paid compensation of a relatively limited amount in a case called Guridi versus Spain, but it also had pardoned and exonerated the 3 civil guard agents who had been the perpetrators of torture against these victims. So despite the payment of compensation, the committee found a violation of Article 14, holding that reparation should cover all the damages suffered by the victim, including, among others, restitution, compensation and rehabilitation of the victim, as well as measures to guarantee the non-repetition of the violations, always bearing in mind the circumstances of each case. And that's, I think, the circumstances of each case is what gives us a little bit of an inkling as to how we have to interpret the right to rehabilitation. Procedurally, states commit themselves to establishing suitable institutions, primarily judicial institutions, to enable victims of torture to obtain redress. It is important that the victims of torture themselves be entitled to initiate such procedures so that their actions are not dependent on the actions, say, of a prosecutor, for example. Substantively, the right to a remedy shall provide redress to the torture victim, which means fair and adequate reparation for pain and suffering. What victims perceive as adequate reparation may differ from case to case and would depend on the particular suffering and on the individual sense of justice. My predecessors have spoken in length about the long-term impact of torture on victims. On the basis of the information received over the 25-year span in which my mandate has been in existence, including direct testimonies excuse me, during fact-finding missions, my mandate has drawn the most common consequences faced by torture victims. It is crucial to identify the many aspects of the impact of torture on victims in order to better appraise and address their needs, in particular from a medico-psychosocial point of view, and to make recommendations that would ensure the most adequate and effective reparations. On the basis of the information gathered during fact-finding missions, and just last month I've conducted my first one. I should have said this before, but I've only been the special rapporteur since last November. And last month I conducted my first fact-finding mission to Tunisia. But on the basis of all the preceding fact-finding missions by my predecessors, and the analysis of findings carried out by organizations working on the issue of reparation, and among which there are several, but I think the Center for Victims of Torture has a special place among the campaigning and service-oriented organizations. My mandate has concluded with concern that laws are inadequate and or lacking in most of the countries, and even where present, they are rarely implemented. The absence of safeguards and the impunity afforded to perpetrators of torture contribute greatly to the prevalence of torture. Impunity is a result of a lack of political will and of the failure to overcome severe institutional deficiencies to combat torture. The outcome is that torture remains unacknowledged, victims suffer in silence, and there is little, if any, official support for survivors. Furthermore, domestic courts are generally reluctant to use international law as a basis for their decisions in the absence of implementing legislation. Among other factors preventing victims from obtaining reparation, the absence of a definition of the crime of torture in domestic legislation, the lack of criminal accountability of perpetrators, in particular owing to amnesty laws and other legal immunity legislation, and the lack of independence of investigatory bodies accessible by victims, were seen in many different cases as among the key obstacles. In addition, most legislation does not encompass the notion of effective remedy. The mandate has therefore recalled that adequate, effective, and prompt reparation proportional to the gravity of the violation and the harm suffered should include the following forms: restitution, compensation, rehabilitation, satisfaction, and guarantees of non-repetition. Another factor is the fact that in a number of countries, the burden of proof is placed on the defendant, or at least effectively placed on the defendant, even if the legislation doesn't say so in so many words. The odds are stacked against the torture victims, and this practice of a shift of the burden of proof preempts proper investigation into the allegation. In other words, the Convention Against Torture has lots of remedies that are obligatory on the states that sign and ratify it, but they're all dependent on being able to prove that torture has happened. And it's relatively easy for torturers to use time in their favor and let matters some time pass so that there are no outward signs of torture, and then the obligation to investigate is not triggered, the obligation to offer reparations is not triggered, and the obligation to offer rehabilitation services is not triggered either. So time restrictions and the lack of standing for relatives of victims, as well as the lack of legislation expressly providing for the exercise of universal jurisdiction, are also identified as barriers of a legal nature against the implementation of an effective and enforceable right to reparation for victims of torture. But I have to say that the main challenge is the lack of political will on the part of public authorities to investigate and acknowledge torture practices inflicted by officials linked up with those same authorities and shielded by them from criminal responsibility. In addition, like other victims and persons who belong to the downtrodden and the destitute strata of national and international society, torture victims often lack access to justice and to effective recourse procedures. Independent judicial and administrative agencies are unavailable, and the authorities are simply incapable or unwilling to set up and maintain reparation schemes and programs for the benefit of victims. It may be that in an adequate reparation scheme, a court can establish the cost of rehabilitation services and include it in the quantum or amount of damages. But even in those cases, services may be simply unavailable, and therefore this ends up, even in those best of cases, being just another lump sum without a serious provision of rehabilitation services. Therefore, from my bully pulpit as a special rapporteur on torture, I'm always going to insist that states take the bull by the horns and establish administrative programs of reparation and of rehabilitation services. By administrative programs, I obviously mean programs that are easily accessible to the victims, that don't demand that they have the wherewithal of asking lawyers to represent them, and they don't have to wait years, and they don't have to go from office to office until they get the necessary services. I think this is especially true during transitional periods in which the transitional government assumes the responsibility of redressing the violations of the recent past. And that's, I have in mind, of course, Tunisia, where there is an opportunity now to create a truly democratic and participatory system. But the legacy of torture and other human rights abuses, but particularly of torture, weighs very heavily on all of the actors currently, trying to open this new era of democratic and human rights respecting governance. And I'm also going to insist, and I have said this several times, that there is the possibility of technology transfer, if you will, between countries. There is knowledge and there's capabilities and there's experience developed by many people, but especially people like Elizabeth, and also by centers like the Center for Victims of Torture. And I've been told by them repeatedly that they are willing and able to help in any way they can to develop the same capacities and capabilities in other countries, but also to offer direct services as much as possible. But even with that high degree of volunteerism, this is not an inexpensive proposition, because services cannot be rendered over a 5-minute visit, and of course, in order for them to be scientifically sound, it requires investment and it requires support. And that's why I am insisting on well-to-do countries to incorporate support for rehabilitation services and for reparations in their international cooperation agreements, especially with those other countries that may be willing to offer redress but are temporarily unable or simply don't have the wherewithal to offer rehabilitation services. The ordeal of victims of torture endures even when the torture itself has ended. Victims experience many forms of long-term physical and psychological damage as a result of torture and ill treatment. We have seen torture and ill treatment continue to be widely practiced in recent public demonstrations that have been held in numerous countries around the world. It is essential to reiterate that it is the obligation of states to prevent, prohibit, investigate, and punish all acts of torture and other forms of cruel, inhuman, or degrading treatment. It is the obligation of states to respect the physical and mental integrity of all persons, to ensure justice and accountability for victims, and to bring those responsible for violations to justice. Moreover, states must ensure that victims of torture or other cruel, inhuman, or degrading treatment or punishment obtain reparation, including redress, and are awarded fair and adequate compensation and receive appropriate and as full a rehabilitation as possible. In this context, while international law and practice require certain minimum standards and principles in relation to redress and reparations for victims of torture, we are concerned that some states only award formal rights, which are often modest and peripheral to the justice systems. We are equally dissatisfied by the lack of progress in institutionalizing basic principles and guidelines which seek to provide minimum standards for victims. It is our conviction that victims must have a central role in holding torturers accountable for their actions. In this respect, I believe that efforts to combat torture require a victim-centered perspective that seeks an integrated long-term approach to adequate redress and reparation, including compensation and rehabilitation for victims and their families. This victim-centered approach to my mandate may mean different things, but I have announced it as the main tenet of the way I'm going to approach the mandate, but I have to recognize, and I'm pleased to recognize, that this is an insight that I got from people like Elizabeth, from friends of mine who have suffered torture in their own countries, like I did myself in Argentina, and particularly from Doug Johnson himself, because the very name of the center that he created puts the victim at the center of the efforts to attack torture and to try to abolish it. I'm not sure that my victim-centered approach is going to be all that different from the way my predecessors looked at it, because I don't mean by saying this in any way that they were not sensitive to the plight of victims. But among other things, I think that the victim-centered approach requires elimination of all the obstacles for victims being able to seek and obtain redress by themselves. And that means, for example, where the legal system does not allow it, that states have an obligation to open up the courts to participation by the victims. They don't have a right to a specific conviction or a specific penalty of a specific torture, but they do have a right to see justice done and to participate in seeing justice done. In the same way, I think reparations and especially rehabilitation should start by seeking the views of torture victims. They know what they need. Of course, it's best if they're assisted by highly trained professionals like Elizabeth and her colleagues, but it's very important to listen to the victims and to ask them, what would it take for you to overcome the heavy burden that is on your shoulders because you have been a victim of torture. So with respect to the rehabilitation, efforts to provide assistance must seek to recognize and validate the traumatic experience of torture that victims have suffered, as well as to prevent their further isolation by reintegrating victims into society. During my tenure, I will continue to support those states, organizations, and other bodies of civil society that are committed to eradicating torture and securing redress for all torture victims. In this regard, I am encouraged by the heroic efforts of various organizations whose work ensures that there are appropriate remedies and reparations for victims. The work of such organizations seeks to include and promote the perspectives of victims and survivors in the development of programs and policies aimed at addressing torture. My predecessors have repeatedly called on governments to strengthen their efforts to provide victims of torture and ill treatment with as full rehabilitation as possible, to incorporate the right to reparation for victims into domestic law, together with clearly set out enforcement mechanisms. This is a goal that I wholeheartedly support and will pursue during my tenure. This year, the United Nations International Day in Support of Victims of Torture coincides with the 30th anniversary of the United Nations Voluntary Fund for Victims of Torture. During the past 30 years, the fund has distributed over $120 million to projects providing medical, psychological, legal, social, and financial assistance to victims of torture and their family members, enabling victims to obtain redress and exercise their enforceable right to fair and adequate compensation, including as full a rehabilitation as possible. With the fund's support, physicians, psychologists, forensic experts, social workers, lawyers, and other concerned individuals or groups have employed a victim-centered approach to assist their clients for years in their long journey rebuilding their lives, to receive the assistance they need. We call on all states to contribute generously to the voluntary fund as part of a universal commitment for the rehabilitation of torture victims and their families, so as to enable it to continue providing organizations with funds for psychological, medical, social, legal, and economic assistance. We also call upon states to support the work of the domestic organizations through financial and other means, as well as to create an enabling environment for the organizations to provide redress and rehabilitation for torture victims. We further urge all states to become parties to the Convention Against Torture and make the declarations provided under Articles 21 and 22 of the Convention on interstate and individual complaints, as well as to become party to the optional protocol to the Convention Against Torture, which is focused on prevention of torture and includes visits to detention centers and prisons in the countries that sign and ratify the optional protocol. I think this effort by the international community, if successful, will maximize transparency and accountability and will make it possible for us to dream of a day in which we can consider torture abolished. Thank you.
Thank you, Juan. Now, Lauren Craner, please.
Okay, let me first thank the Woodrow Wilson Center and CVT for the invitation to be here today. I just want to echo what Dr. Wild said at the beginning. One of the most interesting and most meaningful aspects of doing this work is the kind of people you meet, and I'm very, very gratified to be on the same panel as Elizabeth and Juan. It's a great honor to be with you here today. You both have my highest respect and admiration for all the work you've done. I have not lived this issue. I've looked at it from 30,000 feet. I agreed to be on this panel today because Doug asked me, and I have tremendous respect for him. He asked me not because I'm a professional in this field, but because I did work at the State Department under Colin Powell as the Assistant Secretary for Democracy, Human Rights, and Labor. And Doug said he wanted a perspective of a policymaker on this issue. Doug and I were introduced while I was at the State Department by Mark Grossman, who was then the State Department's #3 official. He's the Undersecretary for Political Affairs. What Mark told me about Doug back then is, I think, a good departure point for whatever contribution I'll be able to make today. Mark Grossman, the guy I just mentioned, had just finished his assignment as our ambassador in Turkey, and he told me that he had seen Doug's work there. Mark told me about Doug's Center for Victims of Torture's approach in Turkey that initially involved doctors, lawyers, politicians, and then ultimately worked its way up to the leaders of the agencies perpetrating the torture to try and end it. Most of all, and this is my main point, Mark Grossman greatly admired the effectiveness of Doug's program in Turkey in beginning to reduce torture. Effectiveness is what matters most to good policymakers. I say good policymakers because, of course, there are bad ones and cynical ones. But in my experience, generally the ones who rise to the top do so because they want to accomplish something for their country, and their measure is effectiveness. As I learned in the years I worked with him, Mark Grossman's a fine and moral man, and I know that torture in Turkey grieved his conscience, and that was a sufficient personal motivation for him to work with Doug. But I have no doubt there was another context for his views on the subject, and that is that Mark's job was to enhance relations between the U.S. and Turkey. Because Turkey's generally authoritarian governance, of which torture was a manifestation, was an obstacle to good relations, especially here in Washington, professionally, Mark wanted to end the scourge of torture there in the fastest way possible. This incidentally points up the need for what I know many of you in this room do, which is advocacy in this town, especially on Capitol Hill, where senior State Department officials must testify, including regarding torture in a country. Mark, seeking to address the issue in the most effective way possible, came to admire Doug's effective program. This is the prism through which policymakers look at one of the two issues that I discussed addressing with Doug today, and that is the issue of when transitional justice should occur. Again, I bow to Mr. Mendez on this subject in general, but as a policymaker concerned with ending authoritarian rule in countries, my prime job at the State Department, I do have some thoughts on this issue. The most basic is that in looking to advance human rights and democracy in a country, you're trying to get the political culture to a point where it is able to deal structurally with, among other things, human rights violations. Sometimes it's possible to ameliorate human rights conditions under an authoritarian government. But I found that in my experience, in a place like in Uzbekistan, where we were able to get Teoban Vovan in, but his work was not as effective as we had hoped it would be, or in a China, in authoritarian countries, moving human rights conditions along quickly is a tough task. Instead, a movement from authoritarian to the beginning of democratic process provides a more effective context for dealing with human rights issues. Again, I will leave it to experts like Mr. Mendez to talk about the empirical evidence, but the prevailing belief among policymakers is that in particular circumstances, especially when the security forces have been helpful or have just stood by in a transition, immediately dealing fully with issues of truth and reconciliation is likely to impede or even derail a transition. The most recent examples where this would be seen to be true, for example, would be the transitions in Egypt and Tunisia. And I was just in a meeting the other day where it was in the U.S. government, somebody was talking from the outside from an NGO about tackling civil-military relations in Egypt, and the policymaker said this is not the time later. It's very, very interesting. One day, no doubt, both countries will be able to deal with their past, but for the moment, it will take the cooperation of the military in both countries to launch them towards that point. A second closely related matter Doug asked me to address is the question, the question in the title of today's panel: do torture survivors have a right to cure? If you've not read it, I would commend to you Doug's excellent article, which I saw outside on the issue, co-written with Stephen Miles. The article points out the political and psychological effects of torture on a population. It also catalogs the approaches different countries have used as they transitioned towards greater democracy. My own personal feeling is that it is self-evident on a purely moral basis that torture victims have a right to care. And it is certainly merits more than the $20 million presently accorded by the United States through the Torture Victims Relief Act to addressing this issue. Looking at the issue through a policymaker's prism, the degree to which torture targets societal leaders is reason enough to offer greater treatment. And by that I mean, if you read Doug's article, he points out that as torture is used to psychologically terrorize a population, they go after the leaders. And there's a gentleman who just came out from Uzbekistan, a guy named Yusuf Juma, who I had worked with for some time, who told me he was repeatedly tortured in Jazlik prison in Uzbekistan, and he told me, he's a well-known Uzbek poet, but he told me his torturers kept telling him, you're one of the most prominent people here, we're going to make an example out of you, we're going to break you, and then everybody else in this prison is going to get what we can do to people. So that's an illustration of what Doug talked about. So in trying to address these issues from a policymaker's prism, linking the degree of need to the practices of governments with which the U.S. aligned, it strikes me, would be very, very effective. In other words, linking the level of funding for these issues to the scale of the problem caused by the security forces of friendly authoritarian governments around the world would be useful. And here in Washington, the most fertile ground for this approach would be in the Congress, probably not in the administration. In addition, I was thinking, I wrote this down, but I was thinking of it as Juan was talking. In addition, as Congress appropriates special funds for places like Egypt and Tunisia, it could be requested that either funds be set aside for redress or treatment for torture victims in those countries. Or one could work also to work with AID to ensure that funds set aside for democracy and human rights activities in particular countries be in part devoted to torture victims. It could also be a role for groups like mine, for the International Republican Institute, the National Democratic Institute, and others who worked with, for many years, with those people who were then unknown but are now going to be heading governments in places like Tunisia and Egypt to hook those new governments up with organizations like Doug's. I'll just conclude where I began, tell a story that involves Mark Grossman, but it points out the need for advocacy. How many of you read a book by Samantha Power called A Problem from Hell? Yeah? I would encourage more of you to read it, and I told all my staff at the State Department, it came out in about 03 or 02, 03, that I wished I could buy them a copy. And Samantha continues her good work now in the administration. It's about all the genocides that have occurred in the 20th century and the U.S., the lack of U.S. reaction to them. And I read it just before the Darfur issue really came up at the State Department. And there were a lot of folks at State that said, you know, we've got a North-South agreement, let's not mess it up by talking about Darfur, the North-South agreement within Sudan. I even had some appointees talking about the idea that if we pursued Darfur, that some of the leaders of Sudan, there might be a push one day for them to end up at the ICC, which the administration was allergic to. Fortunately, there were people like Mark Grossman there, and Mark said, if they're committing genocide, how could you possibly trust them on a North-South agreement? So a number of us were able to work on Darfur. Colin Powell, just before he left, after I had left, was the first, I think, Secretary of State to label a genocide while it was occurring. Unfortunately, as we all know, there was very, very poor follow-up after that. But my point is that there are good people like Mark Grossman in an administration. And my greater point is, as I told you all before, the power of advocacy. I remember trying to figure this out on Darfur, and I finally decided I didn't want to be a new chapter in the paperback version of Samantha's book. So we all better do something. That's the power of advocacy. So again, let me just finish up by saying what a great honor it is to be on the panel with Doug, who I've long worked with and admired, and to those I have just met today. Thank you.
Thanks, Lauren. We want to open it up to questions and comments. We'd ask people to use the microphone. This is being webcast at this point, and we thank Woodrow Wilson for giving us that technology and hope other people are seeing it and connecting to it. But ask a question, please, with the microphone. And where is the microphone? Okay, so while you gather we have a taker right here.
Yes, my name is Jorge Heine. I'm currently at the Latin American program of the Wilson Center here. I'm originally from Chile and a former ambassador of Chile to South Africa during the Mandela presidency, a period that was very relevant, obviously, for the theme that is on the table today. And I would like to ask a question, picking up something that Lon Crenna said, and particularly I would like to address it to Mr. Mendez. The conventional wisdom, of course, is that it is wise to be very gradual about how one proceeds in prosecuting human rights violations, and particularly the case of torture cases, because there's the risk of upsetting the apple cart, as it were. And obviously, in these days, with what is happening in the Middle East, this is especially relevant. And that was very much the approach that was followed in Chile. It was also the approach that was followed in South Africa. There is a book that has already come out, is about to come out, from Catherine Sickink from the University of Minnesota, that is called The Justice Cascade. And what she does is to question this. She looks at the empirical evidence over the past 20 years, and she says it is not true that prosecuting right away the people that are responsible for these crimes will necessarily create great havoc. And what she argues, that all the empirical evidence argues that, in fact, you need all things. You need truth commissions, you need prosecutions, you need investigations, you need a role for in the international criminal court, international judges, and that all things together will have a positive effect. And in fact, there is no downside to operating swiftly and on all fronts. And she particularly cites the case of Argentina, which was originally cited as one case that seemed to prove that it was dangerous to go immediately after the generals. And she said, well, over time, Argentina has done quite well. So I would particularly like to pose this question to Mr. Mendez and also to Mr. Craner. Thank you.
I'm looking forward to reading The Justice Cascade, but I am familiar with Catherine's work on this issue on several other articles before. And I was wondering if Doug, planted this question, but probably not. This would have come up anyway, because Catherine is one of the great contributors to what I think is the current state of the debate about transitional justice, including these questions of the very difficult dilemmas of peace and justice. Meaning by that, how much should we pursue justice if in the short term it may make peace more difficult? And I think conventional wisdom is the right way to approach it, because many of the insights are perhaps counterintuitive. And but I think over the last 25 years, especially starting in Latin America, but following with South Africa and now many countries around the world that face transitions and try to address legacies of very serious human rights abuses, there are first emerging principles in international law. There are crimes that are so egregious that the international law requires some response, leaving aside what exactly that response should be. But Jorge is right that Catherine makes a very strong argument for the response having to be integrated, balanced, complete, comprehensive, holistic, as some people call it, and that means not just prosecutions. It means prosecutions, but it also means truth-telling, it means reparations, and it means institutional reform. Now, the pace and the sequence of all of those things are definitely left to the circumstances and the cultures and the nature of the conflict. You cannot have a one-size-fits-all approach to transitional justice. But the principles are there, and I submit they are international law principles, not just principles of political convenience or of morality. They are those too, but they are now well established as principles of international law, especially when the legacy that we're talking about amounts to crimes against humanity or war crimes. Because now we know that the international community will not tolerate impunity for those crimes. In that sense, the question is not whether you alienate the military in Egypt and Tunisia. By the way, in Tunisia, the military was not complicit, generally, and not complicit in the violations committed by the Ben Ali regime. In Egypt, it looks a little differently. But the question is not alienating them. You do want the institutions to continue to participate, especially in the rebuilding of a country, especially when there is an opportunity to rebuild it under democratic principles like Egypt is looking at now. But the problem is you should encourage and invite the military to do so with a sense of not a misunderstood sort of esprit de corps by which they protect their own and they cover up for the crimes committed by some of their members. The institutions are never under trial. It's members who abuse their power in the institutions that should be under trial. And the institutions are necessary. I mean, everywhere. And I submit that even in Argentina, where at least at the beginning the government of Mr. Alfonsín went farther than anybody thought even prudent, it was never about the army, the navy, and the air force. It was about the people who abused their power in those institutions, and that's why, we didn't abolish, like Costa Rica had done in 1948. We didn't abolish the armed forces, and the armed forces today are, respectable institutions of the state, and they've earned their respect, among other things, by renouncing coup d'etats, by apologizing to the nation, like General Balsa did. But I think, I'm sorry that this is a pet topic of mine, and I'm not going to go on and on with it. All I want to say is that we have a new paradigm in international law and in international relations, and especially since 1998 with the Statute of Rome, but also with other instruments that the United Nations has adopted from time to time. And the new paradigm is when peace and justice collide, we have to find ways in which one is not sacrificed to the other. And that may be difficult to do. It does certainly make peace more difficult, but it also forces us to come up with ideas about what peace should really look like that will probably have the good effect of making that peace more lasting and more durable, because it is not obtained at the expense of justice, and it doesn't leave winners and losers behind. It leaves people who suffered the war and now don't have to suffer the peace. They can now participate in the rebuilding of the countries because now they are recognized as first-class citizens where they weren't before. And there, I think it is possible to invite all actors, including the army, again to the case of Egypt, to look at the new paradigm and come up with forms of rebuilding and establishing a new society that also recognize that the victims have a place in the new society and that the victims cannot be ignored. And among other things, that place includes the ability of seeing justice done and of pursuing the redress of the grievances. I won't say more, although obviously this is an endless conversation, because I do recognize that dilemmas are there. I'm just saying that the fact that the dilemma is there should not lead us to say, well, under all circumstances, peace always trumps justice. It just doesn't work that way, because that's the kind of thing that happened, for example, in Sierra Leone in 1999, with the Lome Accord, and 6 months later, Fordyce & Co. was not only fighting again, he was also chopping limbs again. So that kind of peace is not the peace that we want. Thank you.
Lauren, did you want to take a crack?
I look forward to reading the book as well. I was sitting across in the Interior Ministry in Tunis from the people who I knew had done a lot of this kind of work, and they were suddenly full of praise for the openness and freedom of Tunisia. And I was sitting there thinking, you're going to be in a dock not very long from now. So it was really interesting talking to them after I couldn't get visas to go there like you couldn't for many, many years. So, you know, I said this is conventional wisdom. Doug and I were talking the other day. I am a believer in the conventional wisdom, but I look forward to reading the book. I think there are certainly circumstances in which it would not be true, in which the military, the discrediting of the military had been a big factor, and I think that's what you saw in Argentina. I think where the military is a factor, as you saw especially in Egypt, in trying to usher in a new era, then you do need to think about this. Because if you pursue, you know, it's fine to say that there are only particular members of the armed services, and the armed services themselves are not held complicit. But if you pursue a lot of what was done to its logical conclusion, you start getting into a lot of colonels and generals and ultimately the chief of the army. And then you do face a real dilemma about how to pursue that in the very, very near term.
I want to comment on it. I've had the privilege of reading the Justice Cascade 3 times, and I'm reading it aloud now to someone. And I do urge everyone to buy it because Catherine and I are depending on it to pay tuition money for our youngest son. But the point she's making in the empirical work is that she's taking on the conventional wisdom that says that trials are an anathema to democracy building. And what she finds in the empirical research is, in fact, there's no evidence that that's true. There are anecdotal descriptions of it, but there's no evidence. In fact, the evidence indicates that places that have had the most trials have also, over time, become the most democratic, open societies in transitions. She doesn't assert that trials are necessary. She doesn't think that the evidence is and the data is strong enough to say that, but it is strong enough to say that the conventional wisdom that trials are a danger to democracy is simply wrong. There are differences between ruptured transitions, as in Argentina, and Greece, where the military failed and therefore are kicked out, and negotiated or pacted transitions, where those issues can be more difficult. But in all of those cases, again, what's unusual about the book is actually having an empirical capacity to analyze the issue. But her primary interest in the book is to try and explain how the norm of individual criminal responsibility for human rights atrocities has developed and spread around the world. And that's the basic feature of the book. And I think everyone in the room will like it. It's also really well written, worth the price. While we wait for another question, I have a question I want to throw at Juan. But please identify yourself so whoever's next could get the microphone. Juan, you just organized a meeting of Latin Americans to come together to talk about new strategies to end torture. And you flew in this morning from Chile, so we're very grateful that you're awake. But I'm curious the degree to which the conversation about rehabilitation and the needs for reparations for torture victims entered into the conversation about shaping a strategy in Latin America to end torture.
It did, but I have to say that it came in mostly from the perspective of civil society. The consultation included 10 countries, and it included representatives of government, mostly those with direct responsibility for corrections or for police, and representatives of civil society. And unfortunately, it had to be a closed meeting of experts, so a lot of people who could have made very good contributions were not there. But the governmental representatives, and some were very savvy and very good and had good experiences, were more concentrating on issues like reducing overcrowding in prisons, because the overcrowding itself ends up constituting cruel, inhuman, and degrading treatment under the conditions. And others were more concentrating on how to bring effective prosecutions for cases of torture that unfortunately happen in every country, even those that have really established democratic governance in the region. So it was mostly on the part of NGOs that there was a sense of, let's consider this with all the comprehensiveness that it requires. And it requires prosecutions, and it requires prevention, but it also requires redressing the pain and suffering of victims, and that in that context, some raise the question of rehabilitation, mostly to say that at least diagnostically in the region, it's very little is done, and most of it is done by volunteer organizations, or by psychologists and doctors on their own, but very little is provided in the sense of government services, and urging, of course, that there should be more of that.
Question back here.
Hi, my name is Paula Lopez-Gamundi. I'm with the Council on Hemispheric Affairs. I just had, one question I have two questions, but one question referring to the previous question, I guess the case of Uruguay. In that case, they had two referendums, one putting the impunity law in stating it, and one, once again, reaffirming that the population wanted to keep the impunity law, even though it was only by a margin of 2%. And then recently they had another vote on it again in Congress. I haven't read the book, but I just want to know out of curiosity, what would, I guess, your wife argue about that? How would she, wouldn't that undermine democracy by continuing the trials? But at the same time, what do you do in that kind of situation for the victims of torture? And I guess then I'll ask my second question.
Well, I happen to know Uruguay pretty well, so I'll comment, but I bet Juan knows it even better. So Uruguay is a case of a pacted transition. In other words, it was a negotiation between the military and civilian government. And that's one of those cases where the military had more strength to get an amnesty. The case in the referendum, I think it was in 1989, 1988.
89.
That was a very interesting situation because there was a constitutional provision in Uruguay that allowed a citizens' referendum to overturn legislation by Congress. That was its limited use, but it had never been used in the history of the country. And so the whole process of a massive petition campaign that had to get, I think, about 25% of the voter population to sign the referendum. It was a massive undertaking.
To force the referendum.
To force the referendum, right. And it was exciting to see. And but it was interesting. They lost by 1% in the country as a whole. But I think they won Montevideo by 54%. And I called friends down because they had asked me to give consultations on how to run the campaign. And I called friends afterwards and said, gee, I'm so sorry that you lost. And at that point, in the immediate day, it was, but we won Montevideo. We came this close. Now the military knows this is not an issue of a small splinter group, and that we know a large percentage of people voted against it precisely because of their fear of the military, not because they didn't think they should be tried, but because they feared what would happen. Now, the most recent referendum comes with the complication that the amnesty was not only for the military, but it was also for the Tupamaros. And one of those Tupamaros is now the president of Uruguay. And so the Frente Amplio itself split as to whether to support or not support the referendum. So it's a very, it's an unusual situation. But the most important point I think that the Uruguayans learned was with the one tool we move forward public consciousness, but we have to adopt other tools. And in fact, just as the lawyers in Argentina have been creative, the Uruguayans haven't been as creative, but they've opened up human rights trials in Uruguay now, such as the pact of the amnesty was for the military, but it didn't cover the president who invited the military in to do the coup, Bordaberry. So Bordaberry is now in house arrest, in custody. So there are trials moving forward in Uruguay, but it's taken a long time for them to come out.
Let me add, civilians are excluded from the ley de caducidad, and so Bordaberry and his foreign minister, Mr. Blanco, are both serving long terms. But in addition, the law allows the president to exempt certain cases. And so, for example, cases of abducted children are also being prosecuted. And so, in effect, there are many cases going on in Uruguay right now. It's a little ad hoc, but President Tabaré Vázquez, the predecessor to Mujica, actually certified several cases for trial, and they are going on. So obviously, without prejudging whatever Catherine has written about it, it seems to me that Uruguay is not a case of not being able to do justice. It's a case in which the security of the democracy is also can be traced back to the efforts of civil society to see justice done, even after all of these years. And finally, I have to say the Supreme Court has now twice declared that law unconstitutional. So it's true, in Congress it was, they came again close to by one vote, I think, to overturning it. But quite frankly, a criminal law, it doesn't matter whether you abolish it or repeal it. What needs to happen is to be declared unconstitutional as contrary to international obligations. And I think that's what really matters in the case of Uruguay. And whatever else happens, there is quite a bit of redress and transitional justice going on in Uruguay today.
Thank you for your response. I also wanted to ask, what is one to do with cross-jurisdictional cases of torture, such as, I guess, the U.S. and Guantanamo Bay? I haven't really, like, what would be your policy's prescription for something like that, or your protocol, I guess, to go about dealing with that?
I don't know why you call it cross-jurisdictional. In Guantanamo, the U.S. is the only party responsible for whatever happens there. The fact that it is in a sovereign territory of Cuba has no bearing here, because these people are under the jurisdiction of the United States. In my capacity as special rapporteur, by the way, I have asked to go to Guantanamo, because my predecessor was allowed by the Bush administration to go to Guantanamo, but on conditions that he could not accept. And things have changed a lot since then anyway, so I am still hoping that the Pentagon will allow me to visit Guantanamo. But, stay tuned, I haven't heard yet. But with respect to redress, I think many American civil society organizations, and of course the Special Rapporteur on Torture, will always insist that it's not enough to stop torture and to reverse the torture memos, or to, stop renditions, for example, that the U.S. government and the Obama administration have a responsibility also to explore what happened as a result of the torture memos and a result of policies, and let the evidence lead where it might lead. Not that I expect that to happen anytime soon, unfortunately, but it'll be always a demand, I think, from human rights organizations and civil society organizations, and the United Nations.
Alex?
I'd like to ask Elizabeth to put on her hat as policymaker on Valech. As you know, I lived in Chile for most of the decade of the 1990s when torture was an absolute taboo. Publicly, no one mentioned it. That changed, not least for some of the reasons that you mentioned, such as the fact that the charges against Pinochet came to include torture charges at the very end of his detention abroad and so forth. That was extremely important, but there was also a response from within Chile itself. I also remember that you were involved in the early years of the Lagos government, which did not arrive in office, arrived in office in very, not precarious conditions, but somewhat uncertain conditions, with Pinochet arriving back in Chile almost at the same time as he took office. So it was a difficult time, not quite as uncertain as the cases you've mentioned, but still there were uncertainties involved. And he did not have at that stage Lagos did not have a great determination to move forward on the torture issue. You were involved in discussions inside, in the government. There are a number of other people that I won't mention, but several of us here know, and that discussed what, if anything, the Lagos government could do about the issue of torture that was becoming more and more prominent in Chile, torture that had taken place in most cases many, many years earlier. The main objection from a legal point of view, that is to the route of prosecution, or if you like, the justice route, was evidentiary. These events took place a very long time ago, usually in secret and clandestine conditions. All of the difficulties that have certainly been involved in the very small number of convictions that have actually occurred. Nevertheless, the Lagos government adopted a different approach and decided, in effect, on a second truth commission, which provided the basis for greatly extending reparations. And I wonder if you could talk just a little bit about that experience that you were so much involved in. Because from a positive point of view, and I know, Doug, this is one of the things you had in mind, and we talked about in this today, is trying to see as best we can how it is that actually policies that are positive can actually be formulated. And I think the Chilean example is a very good one here.
Well, the main problem is to prove torture after 30 years or 20 years. And we discussed this a lot because there is the Protocol of Istanbul that can identify the sequela of torture, but there is very few professionals in Chile able to deal with that. But also the numbers, the figures that the people manage about how many people have been tortured were about 200,000 people to 500,000 people. And this is impossible to follow these cases. And for this reason, at the beginning, some of the officials of the government said, well, this is a task that was not possible to follow if we have to prove torture. But then we discussed a lot about the possibility to prove that the people have been in some places, stadiums, jail, or because there is a lot of documents, and also because there is a lot of public denunciation, international denunciation, and then we decided to create different databases, trying to identify how we can recognize and identify the real issue that the people have been deprived of freedom. This is the only situation that we can prove. We are unable to prove torture. And then we decided to believe, because the testimony of the people can describe from different parts of the world and in different parts of the country that they have been tortured, because we receive people that were in the National Stadium in Santiago that declare in Stockholm or in United States or in France. We receive more than 3,000 testimonies from outside of the country, but also from different parts of the country. And we received 4,000 people that were in the stadium. But in the first days of the commission, we received a very exceptional collaboration from someone that we never know. That is a man who appeared and said, I have a book that can be useful for you. And left a book that is, how you can say that, a list of 15,000 people who were in jail, that is a computer list of the army at the beginning of the military coup. It's November of 1973, that have the names, the party, the number of the identification card that we have, and the motivation of, and the place that this person is in jail. And with this list, we can prove in the commission for cases that the people have a very poor testimony because they are very old, they have very few details, and without this list, it was impossible to believe that these people have suffered this condition. And then we think that we can have data for about 20,000 people, 22. The other people, we have to look for other resources and receive the testimony of others that were in the same place. But this implies that the case were very weak in the capacity to recognize them because you can have different kinds of agreements before to tell the same things, But it's like an empirical research that you have 36 cases, then you can cross the information, and then we can recognize about 28,000 people. Now we have the same problem. We have the list of the army, but we have more cooperation of the armed forces and have more information collected. But the people who arrive at this third commission is mainly people who were detained in public demonstrations. And the law was very clear that these people have not the right to be recognized, in spite of they can declare that they have been tortured. The reason of this decision in the Congress when they create the law was thinking in the figures, thinking that we can receive 200,000 people. And this was really, it's really difficult to deal with 30,000 testimonies of individuals and to study each testimony and each case. But if you have 200,000, I think that we need 4 or 5 years. And no one government accepted the idea that to have a commission for this time, this period. I think that this is really difficult because I think we are committing a very unjust appreciation of the victims because we are recognizing only the worst cases, but not the majority of the country. And we receive a lot of people that declare themselves as victims in spite of they were not in jail because they suffer the political repression when they were children, seeing the treatment received of their parents, the aggression against the family. And it's really difficult to prove situations in the case of the peasants in the countryside. We have no possibilities to recognize the situation because they are not denunciation at those times and have no proofs, and no newspapers, no names. And I think that this is an effort, but it's not the last effort. The main problem is the people who were detained when they have between 20 and 40 at those times. And now these people have in between the 50 and the 80s. And I think that it's really difficult to have information, more information, to recognize them. I think that the case of Chile is very strange because we decided to do that in spite of the numbers. But at the same time, we illustrate the difficulties to recognize all the victims. I think that a lot of people in the demonstrations were badly tortured for 2 days, and this enough to produce very bad consequences. And we have a program for rehabilitation. The people have the right to ask for that. We have 300,000 people under this program, but probably we have more victims than that.
Well, I want to be respectful of time. I thank our panelists, thank all of you for coming. Remind you to please come to the museum this evening from 6 to 8 to celebrate Elizabeth's work and to present her with the Eclipse Award. And to also thank the Woodrow Wilson Center for their support for this program. So thank you all for coming.